Good afternoon and welcome to the IU Indianapolis Center for Translating Research into Practice conversation today with Lahny Silva. We're so delighted to have you here. And for this Friday in January, where we're going to have a wonderful conversation and learn some things, hopefully that will be very meaningful for you. So let me share my screen to get us started. We're delighted to have Lahny Silva with us. You're going to meet her in just a moment, but as an introduction, reminder about who we are. We are the Center for Translating Research into Practice, which was the brainchild of the late Professor Emerita Sandra Petronio and our former Chancellor Emeritus, Charles R. Vance. Charles is with us here today. We're delighted to have him. And Sandra's dream when she was on our campus was to have a space where we could have conversations with our esteemed researchers to just talk and learn and think about different ideas and find new connections. And so that's exactly what we've been doing with these Scholar of the Month series, where you can learn more about Lahny if you go to our website, read more about her research, what motivates her, what interests her, maybe find some new connections. We hope that you leave today with a new connection, maybe an interest, something that you'll do or share within the community. So a couple reminders. Here we are in a Zoom environment. So you know how that works. We're asking you to stay muted until there's a time to talk because Lahny would love to hear from you today. And so we'll be encouraging you to turn on your cameras and turn on your microphone so that we can have conversation. But you're also welcome to use the chat feature to share information. We are recording this session, so in case some can't be here or you have to leave early, that'll be available later on our YouTube channel. We'll also be sending out a post-event evaluation. We hope you'll take a minute to just give us some feedback about what we're doing so that we can improve and bring topics that are of interest to you. You can also get continuing education credits for attending these. The way to do that is to sign up. And if you need more information, just let me know in the chat. I can get you to the right place for that. We hope that you'll follow us on our other media channels on Facebook, on X, on Instagram, and also check out our YouTube channel where you'll find not only today's YouTube, but many others of interest there. It is the Vance Community Fellowship time, so that application period is open, but we'd like to remind people that the only way we can continue to do that is by asking for folks to support it. So there is a fund through the IU Foundation. If you're interested or know somebody who might be, you could scan this link here to find out more about how to participate in that way. Or again, reach out to me and I'll help get you connected where we need to go. We really appreciate our partnership with the library in presenting scholar works to you. So if you go to our website under featured scholars and check on Lahny, you can see more about her work. And here, related to the work that she's talking about, are several articles and journals that are easily available to you with a single click. You can also go to the library's Scholar Works site and find more of Lahny's work, as well as all of our translational scholars and other scholars here on the IU Indianapolis campus. It's a great way to help get information out to people that don't have access to journals. So we appreciate the library's support in making that happen. Upcoming events, next month, we'll be talking to Joseph Tucker Edmonds, and the topic is Handle with Care, Black Men, Trauma, and the Perils of Community Engaged Research. So we look forward to that opportunity. And as I mentioned, the Community Fellowship, as well as the Vance Petronio Trip Faculty Awards are open now. And so that closes on February 17th. If you have questions, let me know. I can help you with that information as well. But today we are here to talk with our colleague Lahny Silva, who is a Chancellor's Professor in 2023, a Professor of Law, and a Dean's Fellow in the IU Robert H. McKinney School of Law. She's also known to us as the 2022 Vance Community Fellow, who the topic, as is listed on our site, is community engagement at its best, a holistic approach to prisoner reentry. But today she's going to talk to us about some other interesting things she wants to know more about. So please welcome Lahny Silva. Thank you for being with us today.
So thank you all for attending today on a Friday. I'm really excited about this presentation. I am not very good at technology, so I ask you to please bear with me. Okay, so first I want to thank Chancellor Bantz and Professor Petronio for starting this whole movement here. In honor of Professor Petronio, I really would like to make this an engaged discussion. I am working on a new paper, and this is a way for me to kind of test some of the ideas I have. But I would be remiss if I didn't thank Steve for all of the help and preparation for this event today. I was a little kind of confused about how we did this, and when I learned what Professor Petronio envisioned, it was really right up my alley. So I'm honored to be the Scholar of the Month starting out 2025 in January, and I'm really looking forward to hearing everybody's thoughts. So this is something that I've been thinking about for a long time, felons and firearms. And I have two primary goals today. The first is I want to talk a little bit about felon firearm dispossession, but I want to get your view on what this looks like for you. How are you guys feeling about felon firearm dispossession? And really, in light of the new kind of Second Amendment jurisprudence, which I will review with you today. My second goal is to test the temperature, take the temperature of the community with regard to dangerousness and what that looks like in the context of gun possession. There's a new case that came down called Rahimi, and dangerous seems to be the benchmark. And I really wanted to get your perception, your perspective, and also, get your ideas about what this looks like moving forward. So the agenda for today will kind of go like this. I have two main points. We'll start with felons and firearms, and we will take a couple of polls to take your temperature. And then we'll have a discussion on this specific topic. The discussion will start with me just giving you a quick and dirty summary of the Second Amendment jurisprudence in this area. And then I want to hear from you. What questions do you have? What's your perspective? I'll tell you what my thesis is. I'd like to hear your response to my thesis, and maybe highlight some things that I'm not thinking about or that I may have missed in my own evaluation. Then I'll take you through kind of the Rahimi dangerousness rule. Again, we'll start with a poll, and that is, of course, meant to be interactive. I'll just give you what the rule is from Rahimi. And again, I want to have a discussion, and I want to spend most of our time talking about dangerousness. But in order for me to get there, I have to understand where the community sits in the context of felons and firearms. So, felons and firearms is something that is percolating right now across the country in circuit courts. There is a circuit court split whether or not felons have a right to possess firearms. And so I wrote a paper about it. And the paper really took a real close look at the jurisprudence. And so the polling questions that I have for today are really built off of what I think is the most important parts of these new Supreme Court cases in the rules. So Steve, let's do the first poll. And I ask that you please answer the question, and we'll wait to get the results. So the question is, or the statement is, should all felons be prohibited from possessing a firearm based on the fact of conviction?
So the answers are flying in, Lahny.
Okay,
It's working.
great.
So we'll give people a moment to put their answers in, and then we'll be able to share the results of the poll so everyone can see.
Okay.
So right now, about half of people, a little over half have responded. We're getting closer. We want to give everyone a chance. So here's your chance. Okay, we have a few left. Anybody else want an opportunity? We'll give you just a few more seconds, and then we will. Okay, we are close. I'm
Okay.
going to end the poll and then show the results. Here's the
Oh,
results.
okay, this is really interesting. So most people think that only violent felons should be dispossessed, followed by, and it's not a close second,
No.
uh, no, once released, no one should be dispossessed. And then the last poll result is yes, all felons should be dispossessed. So this is where I really thought most people would sit. So that's excellent. Okay. So we have one more poll. This is the second poll. And I just choose a statement that is reflective of your position. All dispossessed felons should be permitted to petition the government for restoration. Let's see what we get.
About half of the people have responded already, so it's going along quickly. We're almost at 3/4. Thank you for taking time to respond to this poll. This is very helpful. I'm looking forward to seeing what Lahny thinks. I can see it coming up. Can you see it, Lahny?
I
You
can
probably
see it. I can see
Okay,
it. This is
okay.
great, Steve.
Okay, there's a few who are still thinking perhaps. We'll give you just a few more seconds here to make your selection. Okay, well, let's end the poll and see what the results are. Here you go.
Oh, okay, great. So the results are, this is what I suspected, that most folks feel, over half, that all felons should be permitted to petition the government for restoration of rights. And this is actually something that Indiana does allow, is a petition for restoration of rights, including gun rights, followed by only nonviolent felons. And about the same percent of the participants today that found that all felons should be dispossessed. Same, 12% there, 11% here. No felon should not be permitted to petition. So most folks think that there should be some petition allowed. Okay, so where is this really coming from? So as you all know, we have uh, a Second Amendment to the Constitution, and I wanted to give you the text of the Second Amendment, and I wanted to do that because I want you to think about how we are reading rights generally, right? Do the words that are in the amendment, are they reflective of what the rules happen to be in statutes? What do I mean by that? Well, if you look at the Second Amendment, and I'll read it for all of us: a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. So my question is, I always tell my students, you have to start with the text, right? What is the text of the Constitution? What is it saying? What are the words that our framers chose? And my question to the group is the word felon in there? Is there a phrase that says, unless convicted of a crime, or maybe treason, or inciting a rebellion? And those words aren't in there. And this is significant because when the Second Amendment was drafted, as we know, the founding fathers were also drafting other parts of the United States Constitution. And interestingly, in the other parts of the United States Constitution, you can find words that say felon, unless a crime, unless rebellion, and unless treason. So when you're reading the text of this amendment, you don't see those words. And so the idea is that, well, if the framers wanted to make these kinds of restrictions, they knew how to do so because they did so in other parts of the Second Amendment. So I think you guys can pretty much see where my thesis is going here. And so great. So for many, many, many years, the idea was that the Second Amendment was connected to a collective right of establishing a militia. And it was only in 2008 that this understanding of the Second Amendment changed. And so what we have is 3 cases that were decided in a relatively short time frame that establish a fundamental right to bear arms that's connected to an individual right. So what do I mean by that? So when you have a fundamental right, that means it's supposed to be difficult for the government to restrict that right to not only individuals, but to groups. And so the Declaration of the United States Supreme Court that this is now an individual fundamental right means something very, very important in our Supreme Court jurisprudence and for us as the people. So this revolution started with the District of Columbia versus Heller in 2008. And there the court held that the Second Amendment protect an individual right to possess a firearm for purposes of self-defense in the home. So why is this important? Well, it's important because the court, in reasoning through this case, connected the right to bear arms to the right to self-defense, which is connected to the natural right of self-preservation. So now we're moving away from, just these collective rights that you find inherent in the social contract that we all agree with when we live here, right? And we subscribe to American ideals. This is getting to a natural right to defend yourself, a natural right to preserve your life, and to protect really your family. And so Heller sets this bar that was different than the prior cases of the United States Supreme Court in dealing with the Second Amendment. Something was also important about Heller. Heller started the use of this phraseology of a law-abiding and responsible citizen. So in the opinion, the Supreme Court stated that, hey, when we're talking about this right to bear arms, we're really talking about an individual fundamental right that should be preserved for those law-abiding and responsible citizens. Okay. And so that phraseology does in some way create parameters on who should be able to enjoy and exercise this right to bear arms. More significant for our discussion today, the opinion also talked about the presumption of the presumption of constitutionality regarding these felon prohibitions, right? So felons not being able to possess firearms as a matter of a statute or a case law in other jurisdictions. These could be going to be presumed constitutional. It's a rebuttable presumption, but it's a presumption nevertheless, where the petitioner here, a defendant felon, would have to overcome that presumption with evidence and argument. So that's Heller. Well, 2 years later, in McDonald versus City of Chicago, the right to bear arms was incorporated to the state. So for those of you that haven't studied law, when we have a federal law, that doesn't necessarily translate to a right enjoyed by citizens of a state. And this really goes into the nature of federalism. And so what McDonald did was McDonald incorporated this understanding, this right to bear arms as a fundamental right to the states. So it wasn't now just about, the understanding of the Second Amendment at the federal level. This understanding was now taken to the state level and had to be respected by the states as well. And then finally, and for me, the most important case of this gun trilogy is Bruin, New York versus Bruin. And so in Bruin, the rule becomes expanded now. So whereas before with Heller and McDonald, the court was considering issues related to self-defense in the home, what Bruin did was expand that right to the public sphere. And so the holding in Bruin is the guarantee that law-abiding and responsible citizens now have a right to bear arms in public for self-defense. So now we're outside of the home and we're just in the public sphere. There's this right to bear arms for self-protection in the public sphere, allowing really a clear constitutionality of public carry laws. What was more significant for me was the test that was announced in Bruin. So when a United States Supreme Court opinion comes down, there's usually a rule as well as an analytical test that should be used in the future for challenging statutes that are depriving people or groups of certain rights. Well, here, the test used to be what we call a means and scrutiny, right? So if the Second Amendment is now a fundamental right, the government would have to show a compelling interest why it was depriving an individual or a group of that right. Well, in an opinion, majority opinion written by Justice Thomas, he did away with the means and scrutiny test and then replaced it with a history and tradition test, right? So no longer does the government have to show a compelling state interest for the deprivation of a right. Now we look to the history and tradition of a regulation, right? At ready 1791 and 1868 to determine whether or not such a restriction is constitutional. So before I move on to my thesis, I just want to ask if anybody has any questions. Please feel free to raise your hand, take yourself off mute, or ask a question in the chat. Any questions?
I do.
Okay, great.
Um, it may be a side issue, so you can say it's a side issue, but how in the world did they get away from the militia? I mean,
Okay.
that's a single sentence, right? What you show is a single sentence. There's no question it's a conditional. How did they get out of the militia?
So Justice Scalia wrote the opinion for the majority and really parsed through the Second Amendment and called the militia clause just a prefatory clause, right? And this clause, the way it was interpreted, had an implicit understanding that the only way that you could actually have a militia is if the individuals had a right to bear arms. So implicit in the understanding of the Second Amendment is this idea that of course people would have to have this individual right to bear arms if they were going to form a militia. So that's how they got away from that. There's also this division between collective rights and individual rights, right? And so it used to be, Chancellor Bantz, that the Second Amendment was interpreted as a collective rights, privilege, or immunity, right? And so uh, Justice Scalia divorced that understanding by saying, listen, this is really an individual right that is very much in relation to a natural right to self-preservation, okay? You don't need a collective to really kind of carry out the will of the polity. Instead, what you can do is an individual can enjoy this right just to protect him or herself from any harm, physical injury, or death. They don't need everybody to act in order to exercise that specific right. Does that answer your question, Chancellor Bantz? Great. Attorney Cruz, do you have a question?
Yes, thank you, Professor Silva. And Chancellor Bantz, it actually piggybacks off of what you were saying. It's been a while since I've read Justice Scalia's opinion in this particular case. How did he deal with the well-regulated militia part?
Well, that's, kind of where I think Chancellor Bantz was going. And he dealt with it by saying, yes, he didn't say, well, the founding fathers didn't consider that we needed to have a well-regulated militia. He acknowledges this in the opinion. And he says, yes, it was always the founding fathers' idea that we need to have the ability for the American people to form a well-regulated militia in the face of a tyrannical government, right? But really downplayed this idea of the well-regulated militia, as other opinions prior had actually buttressed. He downplayed this idea that a well-regulated militia was necessary, that clause was necessary for the individual rights interpretation, right? Again, implicit in this idea that we need to have a well-regulated militia is the notion that people would have to have arms. You can't have a well-regulated militia without individuals having a right to bear arms. And so if you think that all the way through, are we going to have guns in a shed, right? And then when the people decide to have a well-regulated militia, they go and grab the guns. Or were the founding fathers thinking that people would have firearms, and when there was a call for a well-regulated militia, they would go to that call with guns already in their possession? And for Justice Scalia, that seemed to be the better rationale. You have a follow-up question?
It just does seem to completely ignore the well-regulated part of it. And I'm disappointed that we're 16 years after that, and it seems that this interpretation is only widened. But thank you very much for
That's
the
right. It
clarification,
has
Professor.
expanded. So
Yeah.
your reading of these cases is right on point, Attorney Cruz.
Thank you again, Professor.
You're welcome. Any other questions? I think that there are questions in the chat. I'm having a little difficulty with my
Well, the question in the chat says, how does your thesis relate to American gun control historically and in modern day America?
So I'm gonna actually, if the requester doesn't mind, I want to save that until I get to my thesis, and I will in a second, because that's a great question for kind of where the origins of gun control came from and is at the actual heart of my thesis. I did want to point to what we're doing here in the Seventh Circuit. So I have these bullet points with Atkinson versus Garland, the first bullet point, because this case is coming back up. There was a request for historical briefing, but for purposes of our discussion, I wanted to highlight Justice Barrett's dissent in this case that was decided in 2019 called Cantor versus Barr. And in applying the Bruin test now, it seems that she had a premonition about this history and tradition test. And really her opinion is that, hey, listen, convicted felons can't just, be permanently deprived of this kind of right, right? And there's really more to this. And why not, you ask? Well, what Justice Barrett actually recognized was this. She recognized that history and tradition shows that firearm dispossession has really been intimately linked to groups that are in the minority. And in her dissent, she focused on Catholics and Native Americans and African Americans. And that's where my thesis really is. My thesis is that felons have a right to bear arms under this kind of trilogy of cases, this recent individual rights interpretation of the Second Amendment, both because of the text, which is kind of part one of the test, right? And as I showed you, that the word felon isn't in the text of the Second Amendment, the word crime, criminal, or for certain convictions, right? So the text supports that. Also, felons are considered the people, which is really the heart of what Justice Barrett was getting at there. So part one supports the thesis, but also the history and tradition of these felon dispossession statutes, right? What is the history and tradition of these felon dispossession statutes? And this is where the chat question is really kind of hitting home. Where does it come from? Well, the history of gun control is this, and this is something that a lot of people don't know, is that before America even had two colonies, there was a law in the books and in the Virginia colonies. And the law on the books said this: Native Americans, blacks, and mulattoes can't have any firearms. It was really any weapons, but the word firearms was specifically enumerated. So the very first gun control statute in this country was aimed at dispossessing specific groups. And of course, later on, we know with the American Revolution that British loyalists were dispossessed, Catholics over time, and sometimes Protestants were not only dispossessed in England, but also in America. And so this firearm dispossession has been used throughout American history as a way to dispossess groups that are in dissent with the majority. And that's something that is what we as a country have been worked against. Right? We've worked against kind of singling out specific groups based on race, religion, and other kind of immutable characteristics, and what that means for us as a society. And so my thesis is that the history and tradition of gun control is really kind of steeped in what I would consider unconstitutional reasons today, right? The closest thing that we have on the books to felon dispossession are those statutes that look like what I just stated, right? Dispossession that's related to specific groups. First gun control statute in colonial times was what I just mentioned: Native Americans, African Americans, and mulattoes. When you go into 1791, those types of statutes stayed on the books and added words like slavery or Negro slaves to the statutes. Still, we're having dispossession at the founding based on racial categorization. All right. Also, religion. That's where we saw dispossession of Catholics and dispossession of course, British loyalists. So 1791 is a very important year for the history and tradition prong of the Bruin test. But there's also 1868. That's another time period that we look to see what America's history and tradition of a regulation is. And in 1868, we now have the South enacting the Black Codes, right? And the Black Codes were just a resurgence of the kind of racialized dispossession in a number of different fields, and gun possession being one of them. So the southern states just reenacted statutes that dispossessed Black people primarily. And later you see this with people, with immigrants from Italy and from Ireland. You see these kinds of statutes. And one example is the Sullivan Laws in New York. And so the history and tradition of gun control in America is very much related to a racialized group categorization and dispossession, which would be unconstitutional today. And if that's the history and tradition, well, either the test doesn't work under Bruin or these kinds of statutes are unconstitutional. And my thesis is that such statutes are unconstitutional. So I hope that answers the chat question. So any questions about this before we move on? About my thesis? How are you guys feeling about my thesis? Do you disagree with my thesis? Do you want to unpack my thesis a little more? I really want to hear your thoughts. I do see some of my colleagues on here. I am hoping, since they've heard multiple versions of this, that they will have some questions.
Could we have somebody who's put on their microphone? So Cynthia,
Hello.
go ahead.
Thank you so much, Professor Silva. I learn from you every time. My question is, and I don't know if this paper gets to it, what would be the consequences should your thesis be enacted into law by the Seventh Circuit or the Supreme Court? What do you think the social consequences would be? Thank you.
So I really thank you so much for your question, Professor Baker. I really appreciate it. So in terms of social consequences, I mean, this is such a robust issue right now. I'm not sure there would be anything different that's happening now. And what do I mean by that? I mean, other than, convicted felons, of course, trying to petition the government to get their gun rights restored. So number one, I'm of the ilk that if somebody wants a gun, they're going to get a gun. They're not going to go through kind of the proper channels. They're not going to go to the gun store. So, many of the homicides that we see, kind of in those high crime areas are with guns that were not purchased legitimately, right? They're just purchased on the street. So socially speaking, I don't think that makes our society more dangerous, because felons will now be able to petition a government, or whether that's the federal government or the state government, to restoring their gun rights under the Second Amendment. Also, I think what it will do is it will force these federal government and state governments that aren't doing it to enact a procedure for people to petition for gun restoration. Like, as I said at the beginning of my talk, Indiana already does this in the expungement arena. You can petition the court to restore your gun rights. So states are already doing this. North Carolina just amended their the Supreme Court in North Carolina just said, hey, felon dispossession statutes are unconstitutional, and they amended their code to reflect that. Other states are actually putting in their constitutions, right? Non-violent felons can, of course, have their gun rights restored. And this is all in the paper. I think ultimately it boils down to a question about how we feel about felons as a society, right? There is second-class citizenship. So when felons get out of prison, are we accepting them as full citizens, or are they not full citizens? And if they are full citizens, then they should be given the full rights of American citizenship. And the Second Amendment is part of that. Whether we're comfortable or uncomfortable with the Supreme Court jurisprudence and what that means, you know, for me, it's the issue is deeper. And the issue is, are felons citizens or are they not? And if they are not citizens, then we need to tell them that, right? And we don't do that as a society. Instead, what we do is we stigmatize and we say, hey, we don't care that you're out of prison. You still are demonstrating bad moral character just by virtue of your felony conviction. And my opinion is, if you're not going to accept folks as American citizens, then don't let them out of prison. Right? And so there we are. Do you have a follow-up?
I do. Can you tell? I'm like,
I totally can.
My follow-up is, with the states as they're moving around, have you identified a connection between the states that are changing their laws regarding the process for prior felons to vote, the process for felons to vote even while incarcerated? And I'm just wondering if there might be any connection there for, I think, worthy work in making former incarcerated felons full citizens, maybe even working toward that at a sooner than when they're released from prison.
Absolutely. So most states allow people with felony convictions to vote. It is a myth that, and this was a revolution that's happened in the last 10 years. So most, and I want to say it's 48 states that allow felons to vote, and at all different phases of reentry, right? So Vermont, for example, allows felons to vote in prison. Most states, what they do is require felons to complete their sentence. But there are several states that allow people as soon as they're out of prison to vote. So that's already moving, and it's been moving for quite some time. I did want to circle back to your first question, though, about how this impacts society, because any rule that found that felon dispossession was unconstitutional would only be prospective. It wouldn't be retroactive. So this would just be kind of moving forward. So I think it would be a slow crawl. But anyways, back to your voting piece. I do use that as an example in my paper, my final version of my paper, which is, you know, we seem to be moving in the right direction, right? With having felons recognized as citizens, and with most states doing that, if not maybe all by now. I mean, there's only a couple of states I really need to kind of check in on. But voting is also a different type of right in the jurisprudence. It's a collective right. Right? It's not considered to be really an individual right. A collective right being that, you know, a group of people are exercising their right to get to a certain decision, or in terms of, you know, an election, a certain candidate, right? Whereas this is a different type of right. It's an individual right. And so I do think that there is a difference in the way that we assess these things as a society, right, wrong, or indifferent. With collective rights and felons, it seems to be that as long as other people can have a say, we're willing to give felons a right. And we're starting to see some movement with jurors too. But when we're talking about individual rights, we're less inclined to recognize felons as citizens. And when I say recognize, I mean, it's great that we can say they're citizens, but what is our action? And our action is, we don't want to give felons, right? So I'm actually really happy to see that most people support a petition, right, for folks to try to restore rights. And there's an intermediary there that will evaluate however they think the felons will do with a gun. But ultimately, it's a right. It's an individual fundamental right. The court has spoken. States are starting to move, and we as a society have to determine where we're going here. For all, the criticism of Indiana, I personally have helped people get their gun rights restored through the expungement process, so it exists and it's actually kind of working.
Thank
Do you have a
so
follow-up,
much.
Professor Baker? You have one
No.
more?
No,
Oh,
I do, but I will yield. I will yield. Thank you so
okay.
much.
Thank you so much.
Lonnie, there are several comments in the chat, but I also know you had a couple other poll questions too, and I want to make sure you have time to get to the things you were trying to do before we run out of time.
Oh, it's already running out. I'm really turning into quite a
know.
professor now. Okay, so let's just circle back because I do want to do the other polling questions, and the second half is really important to my next paper. So that is dangerousness. So now, so the Supreme Court has not addressed felon dispossession. The circuit courts are split, but in the meantime, a new case came down, and what it does is focus on dangerousness. Okay, so we have two more polling questions. This is number 3. Tell me how you feel. And the statement is, all felons pose a risk of dangerousness. Let's see how the group feels.
People are responding. We're halfway through. So take a moment and please join the poll. Anybody else want to chime in? There's a few left. Give you another few seconds, okay? All right, this is nearly everybody here, so let's see the result. Here's the results.
I did not expect that. I did not expect 80% of folks here today to think that not all felons pose a risk of dangerousness and that dangerousness should be determined on a case-by-case basis. That's really interesting. I actually thought that most folks would think only violent felons pose a risk of dangerousness. So this is really, really helpful. Okay, great. So let's go to the second poll. Thanks, Steve. Let's go to the second poll under the dangerousness theme. And I'll read it for the group. The statement is, all felons pose a credible threat to the physical safety of others and should be prohibited from possessing a firearm.
And there is a comment in the chat if you want to see that while people are filling out the survey.
I hate to admit this, Steve, but I'm scared to take my PowerPoint off.
Okay, so
Look
it
at-
says the dangerousness component reminds me of how states have divided up ongoing post-sentence restrictions on sex offenders, breaking them into classes based on violence. I think those classifications are largely based on recidivism risk. You may be going here, but are prior violent felons likely recidivists? And I'll end the poll so we can see what the results are too while you ponder that.
I also didn't expect this result, so this is great. Okay, so I want to kind of respond to the chat. So the answer is yes, I am going this way with dangerousness, and dangerousness is not just about recidivism. There are other factors. Dangerousness is usually determined by kind of an actuarial assessment that takes into account more things than just somebody's criminal history. It takes into account the zip code they grew up in, their employment history, their race, so on and so forth. That's how dangerousness and recidivism, for that matter, is typically determined. And so the question becomes, is dangerousness a good kind of benchmark to assess whether somebody should be dispossessed of a firearm or not? Right? Okay. So in United States versus Rahimi, the holding is actually one of the polling questions, right? Where the United States Supreme Court ended up holding that when a court finds that somebody poses a credible threat to the physical safety of others, pre-conviction, never mind post-conviction, then guess what? They can be dispossessed. So we have three cases, Heller, McDonald, and Bruin, that are an expansion of the Second Amendment right to possess firearms, but Rahimi ends up being restrictive. It's like a retrenchment. So what does this have to do with dangerousness? Well, there was a huge discussion in the concurrences, a little bit in the majority opinion written by Chief Justice Roberts, but really in Justice Thomas' dissent. Yes, it was an 8-1 decision, and you have the concurrences by Justices Barrett and Justice Jackson talking about dangerousness and how it's a slippery slope. What does dangerousness mean? Does it mean disrespect for legal norms? Does it mean that folks are actually violent? Are we looking, and if we're talking about behaviors, are we talking about past behavior versus present behavior, right? These are some questions that I called from the concurrences. But Justice Thomas, the author of Bruin, dissented very strongly on using dangerousness as a standard to dispossess people of fundamental rights. Justice Thomas basically criticized the majority opinion for not considering the dangerousness as a proxy for kind of being of a different race or a different religion or of a different ethnicity, and using that as a means to deprive people of their individual rights. And he provided a lot of different examples, but most of those examples were related to Black American history and how dangerousness has been used to dispossess African Americans primarily of any of the fundamental rights enjoyed by American citizenship. And so, what do I think about this dangerousness thing? Well, I agree with the comment on the chat. Dangerousness is a slippery slope. And when we're talking about dangerousness, most people look at past behavior. But what I want to point out to you is this. There are many people living in America's prisons today that are not exhibiting or engaging in violent behavior. I don't know if anybody has really studied the prison culture, but prison is probably one of the most violent places in America. And folks that remain kind of violence free, and I have one gentleman that I'm thinking about in particular. He's in a USP, which is a supermax at the federal level, and he never really gets beyond a medium security prison during his time in prison. He has a history from the beginning of his time in federal prison all the way until he was released of no violence. And so how are we going to judge him? Are we going to judge him from previous behavior where he does have a violent criminal history? Or are we going to look at 10 years later after living in one of the most violent places on American soil? Is he violent? Do we consider him violent now? And so I'm very much in agreement with Justice Thomas here about the court using dangerousness as a benchmark. And I really appreciated Justices Jackson and Barrett's concurrence, at least acknowledging that dangerousness is a slippery slope to categorize people and then deprive them of rights. So how are you guys feeling about dangerousness? What do you think about where I'm going with this paper? And how do you guys define dangerousness?
Can I chime in?
Please do.
So I find this to be very interesting because I have a gender studies background. So I really understand where you're going in the sense of thinking about how groups often get persecuted and then people create rules to justify the persecution. And so you really do want to stay away from slippery slopes for that very reason. And so one of the things I was thinking about when you were talking about like a person being in a maximum security prison and things of that nature, I wondered about sort of the idea of how do you know if a person's behavior in prison is indicative of how they would act outside of prison? And so I think that that's like a very difficult um, sort of question also to think through, because you can think about the fact that when you're being watched as like a human, regardless of what's going on, right? If you think you're being watched, you're going to act a certain way versus if you think nobody is paying attention to you. And also, if you want to get out of prison, a lot of people know that good behavior gets time shaved off, right? So, like, the best case scenario would be that you don't get into fights and that you don't pull shanks and whatever else, violently happens in prison. And so, not that I'm blaming felons or even thinking of them holistically as like a violent group of people. I'm mostly thinking about like violent felons, but I think it goes back sort of to recidivism and how you work that together with like dangerousness. And like I'm thinking a lot about like, yeah, like how would you even determine these sorts of things? Because like for example, that person has been in prison for 10 years. They've acclimated to being in prison for 10 years. So they've like lived a life that's very different from a life that is on the outside in the sense that they don't go to work every day, like an 8 hour job and get paid, like those sorts of things. And they have to pay all these bills. Like your behavior is gonna change partly because of your physical circumstances. So how do you as a lawyer think through these sorts of questions, because I know how I would think about them as like a qualitative researcher, but like how do you try to create rules that don't necessarily endorse making felons like subclass of citizens, but also is aware of the reality that if you had a violent past, you're more likely than somebody who's never had a violent past to be violent again. Like how do you put those things together, if that makes sense?
It totally makes sense. And thank you so much for thinking about this with me. So just kind of a couple of things that I didn't answer before, but I do want to answer now. Recidivism and violent felons, right? So what does that look like? Well, robbery, folks that are convicted of robbery have the highest recidivism rate, okay?
Mm-hmm.
Folks convicted of killing have like the lowest recidivism rate out of all the crimes. So folk, and it makes sense because some of them are sentenced to life, but they also spend a long time in prison, right? So we have one category of violent felonies, which is, and robbery is violent with the use of force, the threat of force, right? So that's kind of over there. In terms of fighting in prison and it being a controlled environment, the truth of the matter is that a lot of violence does happen in prison. If people want to fight with you, they are going to find you and you're going to get jacked up, right? That's just what's going to happen. So, there will always be an opportunity to engage in violence. So yes, you're being watched, but you learn the ropes in prison. You learn where you can get into a fight and you have whatever it is. That happens all the time. So yes, you're getting watched, but at the same time, there's opportunity to be violent if you wanted to be violent. Okay. Now, as a lawyer thinking through these issues, what you got to look at the stats, right? And see kind of what those look like in terms of recidivism and violent felonies. And you have to think about and you have to balance that with when people get out of prison, what's the rule for them? When they get out of prison, are they felons? Are they half an American citizen? Are they a full American citizen? Because we require people to act accordingly and to participate in American society as if they're full American citizens, productive members of society, but they're deprived of these basic individual rights, right?
Like even getting a job.
Even getting a job. So there are, for me, when I'm thinking about a rule, and what lawyers like to do is say, well, we can make a determination on a case-by-case basis. And that's why that was part of my poll, because I wanted to see if you guys felt the same way. And that's really what my perspective is. My perspective is I don't like dangerousness because of the way it's been historically used, right? And I don't, but we have to have some benchmark, right?
Right.
And I do believe that I mean, I think when people get out of prison, they should be restored with all of the rights,
Mhm.
individual rights that come with, being in America. That's what I think. But the truth of the matter is that's not a politically palatable position to take. People
This
don't
is
like
true.
that. They want to see, hey, you've been out of prison. What have you been doing? And so we really like to wait when people are convicted of a crime, we like to give them a certain amount of time to wait before they start asking if they could have some of the privileges or immunities restored. And so with these petitions, that allows people to say, hey, what have you been doing for the past 3 years? Right? What have you been doing for the past 3 years? I'm just really uncomfortable with making people who have been released from prison and who are supposed to have paid their debt to society have to choose between maybe getting killed or going back to prison. That's a
Yeah.
real bad problem for me. And I'm
Especially when
trying
you
to
restrict
unpack
the
it.
options.
That's right.
Yeah.
So I would love to get up with you and talk more about qualitative research. If you could put your contact information in the chat, I will reach out to you because I'm looking to do kind of a project like that with some empirical information.
I would love that.
This
Okay.
I
is
can get
this is
things
a
right
great
now.
place to pause because of the time. We know that some folks have to leave these sessions as we get to the top of the hour, but we always just stay on and continue the conversation. So while we pause here and officially thank Lahny for this engaging conversation, which there is a lot of interest in, and we didn't get to all the things even in the chat. If you have to leave, you are welcome to do that, but we're going to hang out here and keep on talking if you want to stay and stay in the conversation. So reminder, you're going to get a follow-up email. We'll send you some handy links and the slides, as well as some a survey. So please fill out the survey and let us know. But please help me thank Lahny for this time together today.
Thank you. Thank you guys very much. Thank you guys. Attorney